Hi, I'm Denise and you're watching Law with Denise. This is a case summary of McFarlane and EE Caledonia 1994. So what are the facts of McFarlane and EE Caledonia? This case arose out of the Piper Alpha disaster, which took place on an oil rig in the North Sea. Now, this disaster led to the injury of many men and unfortunately the death of 164 men. It occurred when there were massive explosions on the oil rig. And the plaintiff who was involved in this case was a painter who was working on the oil rig. When the explosions began, he was about 550 meters away from the explosions. He was off duty and he was in his bunk bed, but he could hear the explosions. Later on, he was in a support vessel that was being used to save other people from the dangers of this incident. And unfortunately, he witnessed and heard many destructive and distressing things, which he later claimed were the reason for the psychiatric injury, namely post-traumatic stress disorder, which he developed. As a result, he started a case against the owners and operators of the oil rig. When he started his case, there were three grounds that he based his argument for damages on. The first was that he asked the court to recognize that he was in reasonable fear of his life and safety, and that it was this fear which led to the shock, which led to the psychiatric injury. Secondly, he said, you could see me as a rescuer because I assisted the people on the support vessel. And therefore, if you see me as a rescuer for the purposes of the law, it's irrelevant whether or not I had reasonable fear of injury to my safety or my life. All that is relevant is that I was impacted by what I saw. And then thirdly, he said, you could also see me as a secondary victim because I witnessed other people suffer injury while I was out there on the support vessel. Now, at first instance, he was successful, and he was successful on his first claim. The judge at first instance bought the argument that he was in reasonable fear of his life and safety, and that it was this fear which led to his psychiatric injury. The judge did not buy the argument that he was a rescuer, and the judge didn't say anything about his third claim that he could be seen as a secondary victim. However, the defendants appealed, and this appeal went on to the Court of Appeal. Now, what did the Court of Appeal say? The Court of Appeal disagreed with the judge's decision at first instance. They said that they were not convinced that McFarlane was in reasonable fear of his life and safety. And why did they say that? If we look at Stuart J's judgment, he points out that it was actually McFarlane's choice to be on the support vessel. And we learned that there was a designated place for people to stay, to keep safe. And that was not on the support vessel. That was either in or behind the helicopter hangar. So the judges, from the judge's perspective, they couldn't see why McFarlane would choose to be on the support vessel if he were in fear of his life and safety. So they said, we're not convinced that you were actually in fear. So he lost in the Court of Appeal. They also pointed out something very significant. They pointed out that when the judge at first instance simply asked, was the plaintiff in reasonable fear of his safety and his life? This was not enough. They said that after getting a yes to that question, what a judge needs to do, or what the judge should have done next, is the judge should have asked, ought the defendant to have reasonably foreseen that injury could have been caused to the plaintiff? So the Court of Appeal was confirming the law on this type of case, and they were confirming that there are two questions which need to be asked. Another thing that they pointed out was that they did not perceive McFarlane as a rescuer for purposes of the law. They said that any peripheral acts that were done by a person during a disaster would not be enough for us to class someone as a rescuer. So McFarlane did things that were very kind, such as handing out blankets, and he was assisting the people working on the support vessel, but this was not enough. And the court pointed out that if there are peripheral or superficial acts, there will not be enough for one to be classed as a rescuer. They also pointed out that his claim could not succeed on his third ground, being that he was a secondary victim. And that was because they said, as made clear in Alcock and Chief Constable of South Yorkshire, 1992, if one wants to be recognized as a secondary victim, they need to firstly demonstrate that they have close ties with the victim. So they need to demonstrate that they have some familial relationship with the victim. And he had no close ties with any of the victims that were that suffered during the Alpha Piper disaster. So unfortunately, his claim did not succeed on that ground in the Court of Appeal, neither.